Understanding Rescission in Contracts, a Comprehensive Guide. Introduction. Rescission, a legal remedy that voids a contract, is often misunderstood. Misconceptions abound, particularly regarding auto loans and credit contracts. This guide seeks to clarify the nuances of rescission and address common misconceptions, emphasizing the distinction between consumer law and contract law. Here's a breakdown of the key principles. 1. Misunderstanding rescission. Many people incorrectly assume that rescission cannot apply to certain contracts, such as auto loans. This misunderstanding often stems from oversimplified advice from attorneys or online sources. In reality, rescission applies to all contracts, provided you understand the legal framework and contractual nuances. For example, an auto loan is not technically a loan but an installment agreement or an investment security. Understanding this distinction is critical when applying rescission. 2. Consumer law versus contract law. Consumer law, such as the Truth in Lending Act, 15 U.S. C. Section 1635, provides specific rights for rescission. However, it is crucial to distinguish consumer law from contract law. While consumer laws offer protections, contract law governs the broader framework of agreements and their enforceability. Consumer law, designed to protect consumers and ensure transparency. Contract law, focused on the creation, execution, and enforcement of agreements. To effectively rescind a contract, one must understand both domains and their interplay. 3. Key provisions for rescission. Disclosure obligations. Creditors must provide specific disclosures at the time of contract signing. Failure to meet these obligations can form the basis for rescission. Notice of rescission. Simply sending a notice to rescind does not automatically void a contract. Instead, it triggers a process where unresolved disclosures must be addressed. Tendering property. For contracts involving property, such as vehicles or homes, rescission requires making the property available for the lender to reclaim. 4. Legal definitions and nuances. Consummation. In contract law, consummation refers to the completion of a transaction. This term's meaning can vary, often referring to the maturity of a loan rather than the initial signing. Performance. Rescission may require the withdrawal of performance until disclosures are corrected. This allows the obligor to withhold payments lawfully. 5. Importance of specific performance. Most consumers allow banks to hold them to specific performance clauses without holding the bank accountable for its obligations. Contracts are dynamic, meaning roles and obligations can shift based on circumstances. Learning how to enforce specific performance on the other party is key to leveraging contract law effectively. 6. State law versus federal law. Many consumers focus solely on federal statutes, such as the FCPA or FCRA, without exploring remedies available under state law. State laws often provide additional avenues for addressing grievances and enforcing rights. 7. Practical tips for rescission. Study and understand the law, familiarize yourself with relevant statutes and legal terms. Misinterpreting key concepts, such as consummation, can undermine your case. Communicate effectively, use precise language when asserting your rights. Avoid vague or emotional arguments. Document everything. Maintain records of all communications, including notices of rescission and responses from creditors. Consult experts. When in doubt, seek advice from legal professionals well versed in contract and consumer law. Conclusion. Rescission is a powerful tool, but it requires a solid understanding of both consumer and contract law. By learning the distinctions, rights, and processes involved, you can effectively navigate and enforce your contractual rights. Always approach rescission with careful preparation and a thorough understanding of the law to maximize your chances of success. 12. The presumption of guilt. The final presumption is that you are guilty by default. Whether you plead guilty, not guilty, or fail to plead, the presumption stands unless you have prepared an affidavit of truth or a motion to dismiss. Without these steps, the private bar guild assumes authority to detain you until they secure a bond for their financial benefit. Conclusion. The 12 presumptions of court operate as unchallenged mechanisms to assert authority over individuals. To prevent these presumptions from standing as truth, they must be openly and explicitly rebutted. Understanding and challenging these presumptions is crucial to asserting one's rights and ensuring fair treatment in legal proceedings.